Okay, next speaker. A couple of months ago, I was in Montreal, and I walked into a law school class for the first time in well over 30 years. I didn't realize I was walking into a law school class, but it was a McGill tax class run by Professor Allison Christians, who holds the rather esteemed Heward Stikeman Chair in the Law of Taxation at the McGill Law School. And I was so impressed with what was going on, and when I learned that this thing was being organized, I thought, and I was trying to put together, my God, who could be better than Allison Christians? And to my delight, she has accepted our invitation to speak today, and join me in warmly welcoming Allison Christians.
I think you're wrong. I think there are plenty of people that would be better than me here right now, because I'm coming to this a little bit late to the program. So I just start with a little personal information, because if you hear that I'm from Montreal, you already think I'm from another country. I understand that. But I was born here in Toronto, and I grew up in London, Ontario, and then I went to the States on a student visa, and then I got married, and I have 2 children, and I have 2 dual citizen children, the poor dears. And when McGill was looking for a tax law professor, I turned to my husband and I said, if McGill does not bring me back to Canada, we are now committing to living in the United States for the rest of our lives, and I'm afraid I can't do it. Can we go back to can we go to Canada? Back for me, for him. Can we go to Canada? And he, completely ignorant of the entire ramifications of this, agreed. And so here we are. Oh, I just realized I have gum in my mouth. I do that as a professor too, and shame on me, right? So I'm trained in law in the United States, and I've been a professor of tax law in the United States for, it's now 10 years. Before that, I practiced international tax law in New York. You can look up my name, Google me, you'll find all kinds of little threads all over the place. The one who takes photographs of babies, not me. It's a different Allison Christians. So I'm a U.S. tax law professor who's now transplanted into Canada, aware of FATCA when it was passed in the Hire Act. And, you know, the U.S., I mean, the Congress just, the Jobs Act, the Hire Act, the Jobs Incentive Act, you know, they all are apple pie names with the poison on the bottom crust, right? They are all the same. They all act the same way. And so you're never surprised. But what happens is that as you proceed down the path of understanding, you realize the mountain you will have to climb to understand each particular piece of a new piece of legislation. And you sort of delay the inevitable climb by kind of circling around the base of the mountain. That's been me, circling around the base of the mountain of FATCA, saying, oh yeah, this doesn't sound right. Oh, there are some issues here. Oh, that's complicated. What does that mean? And how does this work? And it was only when I actually started blogging earlier this year. And I just happened to put a few things on my blog about FATCA, kind of saying, what's going on? But, you know, I get it. I get what the U.S. is trying to do. In other words, my initial reaction was to be sympathetic to the idea, the package. And the package here is the US, Canada, the UK, Holland, France, Spain, we all have the same problem, and that is a disappearing tax base. The tax base is disappearing into the ether through international planning. We all have this problem where the most capable of contributing to society, those of our most wealthy, asset-rich individuals and companies, are escaping their tax obligations. This is a common theme, and it's reasonable because we all know that there are tax havens, and we all know that there are shady business deals, and we all know now just how deep that goes, HSBC and so on. Right? So the story that forms the context for thinking about FATCA is one I think we could all agree with, and why I think most Americans who look at this are sympathetic. They're saying, wow, the world is engaged in, the wealthy people of the world are engaged in tax evasion. They're running all over the world with stateless income, and no state can control it because every state is subject to the whims of the other states, and as long as there are tax havens, then none of us can control our taxpayers. So we've got to strike back. Now back about 10 years ago, the OECD started looking at this and talking about information exchange and state-to-state cooperation as a means of reining back the rampant, capital flow. All still feels reasonable. Yes, we don't want to introduce income tax systems where only working class people pay. We don't want to have tax systems that rest fully on working classes who earn all of their income from wages and spend it all in consumption, and we get them coming and going. We get them coming when they get that income from the wages, we withhold, and we get them going, we tax them again on those same wages when they spend it in a consumption tax, right? A VAT, value-added tax, GST, HST, right? You're all familiar with this. So am I now, right? So we don't want an income system that hollows out the top and lets them run around the world with no restraints and necessarily leaves out the bottom because they don't have any resources and dumps all of the cost of society and liberty and dignity on the working classes. Still with me? Sounds reasonable. We've got to catch those flagrant tax cheats. But law lumps. When law goes after those flagrant tax cheats, they write some words down. And they try to go after those tax cheats. And it's in this context, in this lane of the pool. But that law pulls everything in the pool into that lane. And that's where we are, I think, in Canada. That's what we're seeing here. At least this is the impression I'm getting from you and from those who have, on my blog, begun to interact with me and educate me as to why I ought to be much more interested in FATCA for personal reasons, not really, but for intellectual reasons, for honesty in the academic enterprise reasons. That is, if I want to call myself an international tax lawyer, and I am somebody who is well-versed in U.S. international tax law, and here I am in Canada, who is better than me to see this and talk about this in terms of justice, in terms of rights, right? But also in terms of remedies. That is, what do we expect from our state? What can we expect from our state? Who is our state, right? Okay. So in that context, again, I started thinking about FATCA as, okay, well, they're just trying to trap that top. And no one, I think, is unsympathetic with that as a goal, but that also muddies our message when we're in the other lane. That is, now FATCA doesn't just, in fact, almost doesn't touch the top. What it does is pulls in absolutely everybody, right, that's foreign. Not just elite, but foreign to the US, right? So, meaning in a foreign place. So let's just take a look now. When I first wrote my remarks, and I'll come to this if you like, but I'm going to talk to you about possible international law challenges and lay out 4 places where I think we can go. But I think before I can go there, now I realize, after hearing the conversation we've already had, that we need to just back up a little bit and make sure we understand who the constituents here are and what our legal issues are, okay? I have this sort of unfortunate view of the FATCA crowd that you are all very well aware of what's going on. And in fact, I have found that within the Isaac Brack Society, within the FATCA community, they know much more than me about this law and have known much more than me. So I've become accustomed to thinking I'm the one that knows the least in the room. So I don't need to explain this to you. You already know this. But just at the risk of explaining something to you that you already know, I think it's worth just thinking about this. You and I are not necessarily affected by FATCA on the front end. That is, it's not, at the beginning of all things, not our job to file the forms, to become compliant, right? You and I are impacted in our, I think, access to banking services. And to understand how that works, let's just think a little bit about how this statute is put together, right? So FATCA's complex And I'm going to oversimplify and probably get a few things wrong, and we'll have to, come back and fix those things at some future date. But again, we're at the cusp of a historic movement, so it's okay to be a little bit, right. Let's hope. So, FATCA is going to say, if you're a foreign financial institution, do we have chalk? Is there chalk? I'm a professor, I can't, So here's our first acronym. If you're one of those, an FFI, so what is that? That's a bank, private equity fund, a hedge fund, a trust account holder, any number of entities that controls funds for others. If you're one of these, then what we want you to do, IRS, we want you to enter into an agreement with us, okay? The agreement is going to be something like a PFFI agreement, a participating foreign financial investment agreement. And in this agreement, you will agree to do this. That's level 1. So seek waivers from all of your identified U.S. accounts. We saw how that's done in the last video, that we're going to identify accounts. We can come back to some of the legal problems. There are many with that. But you decide who might be, could be, possibly a U.S. account. Put that red stamp on there, right? Could be treated as. Doesn't matter if it actually is a U.S. person, only just if you think of reason to believe it is. Put the stamp on it. Ask everyone with one of those to sign a waiver of their rights to their financial privacy in your institution. If they will not sign it, close the account. Now, if you sign the waiver, sign the waiver. So when you sign the waiver, you're doing two things. One, you're agreeing to give your bank any information it asks of you. And two, you're agreeing that your bank can disclose that to the IRS, not to your government, not to the CRA, to the IRS. We're going to come back to that distinction in a minute. Okay, so you're going to give your info, you agree to give it, whatever they ask of you, for now until forever, anything they ask you. What color underwear are you wearing? You have to tell them. Am I exaggerating? Not by the language of the statute. It says anything the secretary asks. They can ask you, and you will turn it over, and once one of those PFFIs is signed by your financial institution, they're agreeing that they will agree to give the IRS whatever else it asks, from now until forever. So it's not a closed agreement. In fact, we don't have any to look at. But the idea is, once signed, secretary has carte blanche to ask the financial institution for anything, and they will go to you and ask you for that, and you've said you'll give it. You've agreed. Now, if you say you'll give it and then you don't give it, you become this is how you become a recalcitrant holder. That is, you only become one of these things if the financial institution has signed the agreement, the PFFI agreement, and you've agreed to give the information, and then you don't. Punishment? 30% withholding tax. On what? Any U.S. source cash flow. Now, this means interest, dividends, blah, blah, blah. But here's an interesting piece of legislative craftiness, creativity. If you own property in the United States, and it's capital property, and let's say you paid $1,000 for it, and you go to sell it for $800, gain or loss? Loss. However, you have $800 of cash from a U.S. source, which is subject to 30% withholding. Right. I've got a U.S. expert in the room, so please, if you disagree, you won't give if you say you'll give your info, but you don't, you're a recalcitrant holder from the bank's point of view, they must withhold on you. And let's just step back, wait a minute, but how, It means that anyone that pays the bank, and this is your point before, anyone that pays the bank US-denominated funds is a withholding agent for US purposes from 2010 forward. It means that currently, right now, that is the status of the law right now. Yeah, they're not enforcing FATCA yet, but the fact is that you have a statute on the books which identifies, which makes a category of withholding agent on withholdable payments of the whole world. Any payment to your financial institution from any other payer, the US can go to that other payer and say, you have to trace. You're going to give TD $100? Well, where's TD going to put that money? Does TD have any of those guys? Because if TD has any of those guys, we, the payer to TD, have to take $30 and give it to the IRS. And then, I don't know, somewhere along the line, I guess somebody can apply for a refund, but who? Right, so there's a tracing, we call that the pass-through payment. That's where you see the pass-through payment. Okay, so now we have a PFFI. You give your info to the bank, your bank, and you give consent to your bank to disclose it, which it would otherwise not be able to do under PIPEDA. That's where we were before. Okay. What if your bank says no PFFI? Then all payments to the bank are subject to the 30%. So it's sign the PFFI or all payments. Okay, so do you remember the Pirates of the Caribbean? Oh, I shouldn't give you more red meat, but I will. In the Pirates of the Caribbean, he says, now you can surrender now and most of you will die, or you can put up a fight and all of you will die, right? That's where we are, okay. So he said it better than me in the movie. But anyway, it's a great film. The PFFI, let's just think about this. Even if I'm TD and I sign the PFFI, it doesn't mean I'm exempt from withholding. By no means am I exempt from withholding. I have an annual, in fact, it's I believe 3-year requirement to keep checking to make sure I don't have any of these recalcitrant account holders, to keep checking and make sure I have identified all my US account holders. And even if I am compliant, PFFI compliant, I still have a 30% withholding tax with respect to all those recalcitrant taxpayers. So it's building in a withholding succession from the initial source of the payment through any intermediary that might eventually somehow possibly get to someone who could be, doesn't necessarily have to be, in fact, but could be a US person. Now, when I first saw this and pieced through it, I thought something just not, it can't be how this is, but in fact it is. So now we get to the beautiful, oh, we can get out of this. There's a get out of jail free card here. It's very simple. Here's your get out of jail free card. If your country, if your state, that is Canada, in the case of TD or BMO, what are the other three? RBC, Scotiabank, who did I miss? CIBC. I don't know, we have this Desjardins in Quebec. This is different, okay. All right. Oh, the Caisse, the Popular, those kind of things. Anyway, you can get out of the PFFI if your government will sign an IGA, which is called an Intergovernmental Agreement, which is being packaged as if it was just another information exchange agreed to in a treaty you already have. Okay, just come with me on the fiction on this, okay? You cannot get an IGA with the US unless you already have a treaty, because the whole point is that the right to withhold or share information is emanating not from the IGA, not from FATCA, but from the treaty. The law that gives the right to the United States to compel information from other countries has to come from somewhere. They can't just get it. We have to consent. The other state has to consent, right? Now, the IRS is saying, well, we can do this PFFI because that's voluntary consent to, by every person in the chain to give up whatever right they had to state protection. And what we're saying is we'll give you another right. Your state can give it up for you. So here's how your state gives it up for you. They sign this intergovernmental arrangement, which reads with all kinds of fancy whereas clauses and therefore clauses, but it starts out saying, naming the treaty So in the case of the US-Canada, the US-Canada Treaty signed in 1980, what was it? I can't remember, and updated through blah, 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 right? Pursuant to Article 26, exchange of information. Now, therefore, come ye all who will listen here. Now, therefore, Canada, CRA, under existing rules, namely PIPEDA, will ask for the information the US wants itself. Instead of asking your financial institution to get it from you, CRA will get it for you, from you. In other words, there exists in PIPEDA, I mentioned this before, so I'll just repeat, right? You have low financial privacy when it comes to the CRA. You know this. You have to report. You have to give them your whereabouts and your wherefores. You practically have to tell them how much more you weigh this year than you did last year. You know this already. You waive a lot of your privacy rights in that statute. It doesn't protect those privacy rights, right? Low financial privacy, but only vis-a-vis the CRA. Even the CRA has restrictions about, Canada Revenue Agency, even the Canada Revenue Agency has restrictions about how they can use your tax information against you in other legal contexts, right? They can't just, let's look through your, it looks like maybe you're engaged in some sort of fraud. Let's go after you under some other, it's not that straightforward, and we can talk about that, and there's people that are much more expert than me to explain what the CRA can and cannot do with your information. But let's assume a low threshold of privacy for CRA. They can take what they want from you. However, you have a higher right or expectation of privacy with respect to third parties, right? So PIPEDA prevents disclosure. That is, the baseline of PIPEDA is to say to your bank, when it collects information from you, your name, your address, how old you are, how many children you have, how many accounts you have, and account numbers they give you, they're not allowed to disclose that to anyone under PIPEDA except for the CRA, right? And we have the Financial Crimes Network. We have these other, okay. So PIPEDA is giving you financial privacy against all other comers. That is, your bank's not supposed to sell it to YouTube. And they can't give it to the newspaper to publish on the front page. But they can now give it to the IRS if the Canadian government agrees to get it from you, right, through the IGA. Now, I think here's where I'll try to pick up from where I had originally started with this conversation, which was to sort of start with that conceptual baseline, assuming that we all had that knowledge. Now let's think about this. I missed it when you put up your hands about how many duals were in the room. Can you put up your hands again for me? Is it, okay, but former dual is bad enough, right? And is anyone like me a single citizenship but other residents, permanent green card? So I'm your only green card holder, okay. Okay. So I'm just trying to get a sense of the constituency, because I think one thing to always keep in mind, and one thing I'm really curious about is whose benefit is this in? Obviously the big four. That's the big constituency that all of you will be working against, because any way they can extract money from you, you know what I mean by the big four, right? The accountants, yeah? Any way they can extract money from you, so much the better. That's like a jobs plan. That's what we really mean by the Hire Plan or the Jobs Act. What we really mean is how do we extract more from, yeah. Okay. Okay. So here's a couple premises for you. The first premise is this, right? If we're starting to think about now, okay, this sounds bad and it's ugly and geez, can the US just kind of roll in with a steamroller and do that? Well, yeah, political economy-wise, yeah, absolutely they can. They're huge and you can't live in the world without the US. Very difficult, right? Unless you're maybe China. Knock on wood, right? So if China goes a certain way, then maybe we have an easier way. But we've already been betrayed. Canada has been betrayed by her own, I shouldn't say this, I'm on film, by her own mother country, by the Queen herself, right? Because the UK has already entered into an IGA, making precedent, making us look bad. Somehow we're hiding fugitives if we're not doing the same thing. This is a bad place to be. Worse, a couple weeks ago, Mexico. So 2/3 of NAFTA is on board. Are we going to hold the line? Okay. So here's the premise. We want to start thinking about, well, where are the challenges? And I think that's where you started. That's why you asked, what you asked me to look at is how can we think about, is there a pushback? Is there a pushback on this? Okay, so the premise, there's a couple of premises here. The premise is that FATCA imposes requirements on providers of banking and financial services to Americans living abroad that are first, inconsistent with domestic laws, and second, more onerous than those imposed on US financial institutions, right? So there's sort of two ways to frame this, but actually now I think there's three after the conversation we already had. I was thinking more, this is very typical, I was thinking more about it from the US perspective. Isn't that ironic, right? But that's what happens when you study in the US. You think of everything from the US perspective, you forget to think, oh, well, maybe there's a challenge under Canadian law here. Okay, so you've taken care of that, though, for me. Thank you very much. From the US perspective, there's two frames. One is that the US is violating Canada's autonomy. I won't say sovereignty, right? Because there's a lot of baggage bound up in that term that won't resonate when you push forward, okay, legally. So if you talk about violating sovereignty, I understand, I know it's a popular way to talk about it, and it's fine, and go ahead, we can talk about that. But I think when you sort of dig into what expectations there are, we're really talking about autonomy of nations, right? To create their own laws and be safe from intrusion. And when you talk to sort of international law scholars about sovereignty, they will say sovereignty is a binary concept. Either you're an independent state or you're not. You can't give it away, you can't sell it. I think there's a lot of contestation in that topic, and I'd rather just leave that aside and get right to the heart of it, which is autonomy. That is Canada going to be allowed to have its own banking law or not? Right? And that is it could be a question of sovereignty, but it's certainly a question of autonomy. Okay. So that's the first frame. And the other frame is the US could be violating Americans' geographic mobility, right? Stopping Americans from leaving, sort of trapping the American in the States. Wherever you go, you're hounded by this. And I think there's some sense that you've talked about that. Okay. So question for me as a lawyer or thinking in terms of legal ways forward is, do either of those frames lead us to a viable legal cause? And I think the answer is yes, but don't get your hopes up. This is anything but easy, okay? So I think for us, the challenge is just to first work through these premises. Are they real? The first one is that there's an inconsistency with domestic law. I think we've already seen Pipita as that issue here, and I think we could say, without a doubt, there's a clear inconsistency with domestic law. That is not in question, I think. And I think that's so uncontroversial that we ought to be just saying that sort of constantly. This is inconsistent with domestic law. This is inconsistent. That is, FATCA is asking financial institutions to break the law in their home countries. And if they won't break the law, the remedy is not give services to residents of that country. Canadian citizens who are resident in Canada. So either you've got to waive your right under a law that gives you rights in Canada, or you've got to give up your account. And FATCA is imposing that, I've called it a Morton's fork, a choice for which there is no not giving up of something, right? That is imposed not by Canada, but by the US. And it's not imposed on you, Canadian citizens, but on Canadian financial institutions, right? So you are not being given that choice at the front end. It's being given to financial institutions. They can choose not to sign the PFFI or not. That's their choice, the financial institutions, not your choice. You can't choose that. Once they choose that PFFI agreement, now they give you the choice. Waive or close. Third option, waive. Then don't give them the information and pay the 30% as a recalcitrant holder, right? Okay, so clear inconsistency with domestic law, and I think first thing is to win the public battle of rhetoric. Now, I talk like a law professor, and clear inconsistency with domestic law is not a good message, not a good package, so we have to work on that. You know, that's your job, right? You know, if you're trying to create some sort of public understanding of an issue, there needs to be a package for that, a language package, you know, a marketing campaign to think about what does that mean. If you want to say violation of sovereignty, go ahead, but consider violation has 4 syllables, sovereignty has 3. Most people don't know what either one of those means. So we need a better package, just a rhetorical way to talk about what I think is well documented, and I think there is no question, and I'll say, I think we know it's inconsistent with law. It's written in the IGAs themselves that the reason for entering into the IGA is the inconsistency. That's the term they use. That what we're asking you to do is inconsistent with domestic law, therefore you need you need an IGA to fix it. It's in the IGA itself. The US is acknowledging we have an inconsistency and nudging Canada to fix it. Not themselves, Canada, and all the rest of the country. So if there's a way to think about just rhetorically how you package that, that's, I think, a step forward. That's not a legal step forward, but that is a way to win the public mind, to start bringing, so the room has 3,000 people in it, saying, what is this outrageous thing that I have to take 3 hours just to understand, let alone understand what to do about it? Okay. Clear inconsistency with domestic law needs some better rhetoric. Premise 2, more onerous than for US companies. Well, there's a little problem with that, and that is that in the Revenue Code, it says that your financial institution can elect to be treated like a US company, which is worse for you, but it means there's parity. Parity. That is, there's no discrimination here. IRS can say with a straight face, hey, we're treating everybody in the whole world just like US companies. You can just elect to be treated like a US company. It's right there in 1471. I don't have the site right with me right now. C, I think. 1B. There's a lot in there. 1471, B1C something. Okay. So, but I think what we can say, though, is start to say, well, wait a minute. Canadian citizens who are also US citizens have a double burden here. American citizens living in the States with Canadian citizenship do not have that. So I set up in my mind kind of a disparate impact case, just, you know, kind of noodling it through. What you need is an American citizen with a dual living in the States and a dual living in Canada. And the dual living in Canada has 2 countries, both doing the same thing. And the one living in the States only has 1, because Canada doesn't do this to Canadian citizens abroad. Okay. So it's just one way to think about, well, okay, you have parity in the statute. It looks superficially, it looks egalitarian, it looks equal treatment and so on, but is there a way kind of to think? So you sort of think about case studies, stories, and start to try to tease out some sort of inequity. And injustice that is being perpetuated through a statute that looks facially neutral, okay? So those premises are troubling. So where are the challenges? Okay. So I thought the first challenge that occurred to me was international law. But the more I thought about it, I actually thought, well, wait a minute. Couldn't a US citizen mount a constitutional challenge in the US of FATCA as violating the US Constitution, but on what basis, right? So we would need a US constitutional scholar to kind of think about what rights you have to mobility, to geographic mobility, to leave, to come back, to, I don't know. It's pretty tenuous, I think, but I will say this, I doubt any American constitutional scholar has ever looked at FATCA, has ever even asked themselves, what is this statute doing to Americans who go out, right? So restriction of freedom of movement, well, it's not a right in the US, I don't think. It is in the EU, but we don't have any 4 freedoms in the States. We don't have any freedoms in the States, right? So I don't know, it's sort of something, you know, sort of a thinking about, just we gotta brainstorm a little bit and think about what could there be a constitutional challenge. Good grief, Americans challenge the IRC all the time on constitutional grounds. Mostly it's baseless. Maybe we can give them something to work with, right? Give those people who are like, let's give them something to work with. They're always looking for some kind of constitutional challenge, and they're usually way off in left field, walking around in crop circles, talking to themselves. Let's give them something, meaty here. I don't know. Just thinking about people who are already active to an overreaching government and navigating the state-citizen relationship, right? What can a state do to me? What rights do I have vis-a-vis my connection to the society? Okay. So the problem, of course, is that U.S. is obviously very conservative in so many ways, but certainly when it comes to constitutional interpretation. So I think it would be difficult, but it creates a pressure point, right? Many times litigation is not about winning. It's not about having a great case. It's about publicity. It's about rhetoric in the public sphere. It's about activating people's imagination to think, oh, a wrong is being done. This is serious. And to get more people to sort of see it that way. And I can tell you, living in the States for 25 years, nothing Americans like better than a constitutional law challenge. They don't care about taxes, many of them. They don't know enough to care about the technical details. But a constitutional challenge, in terms of like legal, academics, policy folks, and you get people activated. So, oh, what's going? Is there anything here? Maybe there's a way to activate some imagination. Even though I think ultimately it will go nowhere, probably. But I'm not a common law scholar. Maybe somebody really much smarter than me can come up with something here. I don't know. Okay, so barring constitutional challenge, which is outside of my bailiwick in any event. Now let's think about international laws. I've got four. I got four sources for you. First, we should be talking very loudly and very strongly, in strong terms, about the tax treaty override, right? So the last time U.S. overrode the Canadian tax treaty, the U.S.-Canada tax treaty, was when the U.S. Adopted the branch profits tax in 1986. Now, if I just lost you all because you have no idea what that is and don't really care, that's fine. But here's what I'm going to tell you. The outrage over that tax treaty override was such that it actually led to kind of some concessions being dragged out of the U.S. on the part of Canada when they redid the treaty to make it not be overridden anymore. In other words, here's the thing. Mini U.S. law seminar. A treaty in the U.S. is equal to the law of the Constitution, law on the books, legislation, case law, equal. Which means later in time rule. Whichever one is the most recent, that's the law, right? Just like a common law kind of precedent kind of thing. So U.S. signs a treaty with Canada, says we're going to impose this kind of level of tax. We're not going to impose tax on capital gains of Canadian residents earned in the U.S. We're not going to tax dividends up higher than 15%. We're not going to tax interest higher than 10%, 5%, whatever it is, right? Then if the U.S. decides to put a new law on top and said, no, we're going to change all that with the legislation, that legislation now applies instead of the treaty, last in time rule. So in other words, the U.S., and is, again, one of the few that can do this, can unilaterally override a treaty. They don't have to terminate the treaty. They just write a new law that negates it. They did that with the branch profits tax in '86. They're doing it now with FATCA. It is a clear tax treaty override. I don't think there's any question in my mind. And the reason, again, I see it in the statute. Because in the statute, the PFFI has to waive, the PFFI now, you're going to ask you to waive your rights, but they have to waive a right too. Guess which right they have to waive under the statute if they're going to sign this agreement? Any rights under any U.S. treaty with Canada, right? That means NAFTA, the double tax treaty, and if they ever get the thing signed, FTAA, right? Foreign Free Trade Act of the Americas, Free Trade Agreement of the Americas. They'll never sign that thing. You know this. It gives investor-state, arbitration, a door into, pressure on the U.S. So forget it. It's not going to get signed. Watch, tomorrow they'll sign the thing. But anyway, it doesn't matter. The point is, the PFFI, under the PFFI agreement, you waive any right under any U.S. treaty. I'm telling you, I looked at that twice. Like, really? It doesn't just say the double tax treaty. No, any treaty. So you can't come back and say disparate treatment between U.S. and foreign. You can't come back and say, this looks like a subsidy to U.S. financial institutions. And don't think that they don't see it. They're advertising to you to move all of your accounts to the States, to save yourselves from FATCA. Yeah? This is going on now. That is, you have American trust account managers, mutual fund advisors. If they haven't woken up, they're waking up now to tell you, take your money out of your RRSPs, out of your whatever's here, and put it in the US. Don't have mutual, if you're American abroad, don't have mutual funds in Canada. You can't own those here. You gotta own those in the States. Yeah. So don't think that we don't already see that. So, but what you're saying as a financial institution is you're absolutely waiving your right to raise any kind of subsidy claim under the WTO, any kind of NAFTA, any kind of tax treaty challenge. You don't have it anymore once you sign that PFFI. Okay. So I think we can be talking very loudly about tax treaty override. That requirement to waive any rights under any U.S. treaty is in 1471 C3C. That one I wrote down. And IRS claims this is no override because, again, they're saying it's voluntary. But the thing is, if there's no treaty override, then why do you need a country-to-country IGA? You wouldn't need it if there wasn't a treaty override. You just wouldn't. The competent authorities could just agree to do whatever it is they're asking you to do. So I think we're being sold a little bit of a bill of goods here, in that there's a sort of protest. Oh, there's no treaty override. There's no treaty override. Don't believe it. You heard it from me. There's a treaty override, because if there wasn't, they wouldn't write that in the statute, preventing you from bringing up any treaty, and they wouldn't write into the IGA the recognition that they've got to do this. Right? Okay. So I think it's there. I think it's being admitted through the precautions that have been made in the drafting. I find it fascinating. In fact, I've been sort of writing back and forth with one of my longtime blog readers, one of your folks, saying, I wish I could have been in the room when they wrote that clause under any U.S. treaty. What were they thinking to themselves? Like, what were they saying? Why do we need that? Somebody verbalized the need to waive rights under all treaties. To get this, that's not minor, I think. Okay, so barring constitutional challenge, the first step, I think, is tax treaty override. It is happening, it is now, it is objectionable. Finance minister should not agree to that. No competent authority agreements agreeing to that. No behind closed door agreements, agreeing that we're not going to call that a tax treaty override. It's a tax treaty override. We should be using that language, because that is, in fact, internationally very much frowned upon. If anything is close to being as reprehensible to people as citizenship-based taxation, it's the U.S. tax treaty override. People don't like it. Europe hates it, right? They hate it. The idea that you could put your own law above a treaty that you already negotiated. You make a deal, and then you just make a new law on one side, right? People get exercised about that. They really hate it, so let's give them some red meat, right? Tax treaty override. Okay. So that brings us to NAFTA. I am not, and this is why I said much better people than me you could ask here. I think there are people who are experts on NAFTA. I am not. I am not one of them. But I feel like there are people who are looking at this. I know that there are people that are looking at this. One of them is, I think, Art Cofield at Queen's University here in Toronto, somebody we should watch, right? Look and see how they construct that argument. I don't know what the legal, how you put together a NAFTA argument. I know it's expensive, okay? We need to get more information. We need to be talking to people who mount those challenges, because, again, like a constitutional challenge, it doesn't have to prevail, right? You don't have to win the case. You have to make it expensive for the other side. You have to raise public awareness that there's a big problem here, right? You get people exercised that the U.S. signs agreements and then just does whatever the hell it wants, right? You've got to get that message out. Right? That you're no point signing agreements with the U.S. because they will turn around tomorrow and negate whatever you agreed to yesterday. Just tell you got to give them something else now, right? Let's get that message kind of into the public dialogue, right? Into discourse. You might not win any court challenges on that, but you get that message out, right? We know that. We all know. Nothing's new here, unfortunately. And you might be, fighting an uphill battle. None of us will get there. But I think as a professor, as an academic, and as someone who thinks about rights and justice, you can't stop and say, well, it's not worth fighting because we're going to lose. You have to say, well, we keep advancing the ball one tiny little hair at a time. Eventually, we somehow get there. Okay, so that's tax treaty override. Say it over and over and over again. Say it with me. Tax treaty override, yeah. Okay, we got NAFTA, probably. I think we should be looking to experts to help build that case. Right, just to look at it. I know it's probably hopeless. Let's look at it anyway. Somebody creative out there is going to see something in there, right? The third one doesn't pertain to Canada as much, but it's other free trade agreements, right? So that creates investor-state dispute capacity. Now, maybe we can't do that because Canada doesn't have a free trade agreement, but the U.S. has 20 free trade agreements. Let's lend our expertise to everybody that's got a free trade agreement with the U.S. and say, we are going to help you use the FTA as a platform to challenge privacy intrusions, right? De facto subsidies for U.S. financial institutions, if that's in fact a case that can be made, right? That are being perpetuated through FATCA, right? In other words, any line of attack. Okay, the fourth one then, and I think the worst and hardest, but still I think has to be made, is in what we call international law, which of course doesn't exist. So that's our first problem. There'll be some people will start talking about customary laws being violated, customary laws being challenged by the U.S. Move with FATCA. Okay, the idea would be that with FATCA, U.S. is violating sovereign entitlement to regulate in the territorial jurisdiction, right? It doesn't ring, but you understand what I'm saying, right? Now, the idea, again, just to simplify that further, is to say, well, the U.S. is violating Canada's right to protect the privacy of its own people in their day-to-day financial activities. Canada has a right to protect that, and the U.S. is forcing Canada to abrogate that. Canada has a duty. Well, we have to think about that. Right? But the U.S. is forcing a wedge between a relationship, a social contract, if you will, that Canada has signed with its own people as to privacy, and the U.S. is superseding with its own rule on privacy. Right now, this is not a new argument. This has been made in other contexts, and what we need is somebody who knows how to make that kind of argument, help us to make that argument for this tax rule, right? See, I told you I'm not that helpful here. Don't know all these laws, right? Okay, so the trouble, I think, is that what I do know from international tax law is that if there is any kind of customary international tax law, I have never seen it. I don't know what it is. People say residence-based taxation is a customary tax law. There's a professor in Michigan who says that. He says that's a customary law. Every country has agreed to it. So I have the unfortunate task of telling you that unfortunately, almost every country reverts to citizenship taxation. They do it through treaties. And I want you just to know this because I want you to see just a little taste of the complexity in thinking about this from an international law perspective. In Canada, we have our own rules, sojourner, residence, and ordinarily resident. We have all of our rules for deciding who is Canadian, who is us, right? Who is our taxpayer, right? And the U.S. has its own rules, and Switzerland has their own rules, and Norway, and so on. Now look at the treaty. Almost every treaty is based on the OECD. No, every treaty is based on the OECD model or the U.S. model, which is a derivation thereof, or the UN model, which is an even more derived version. But anyway, they're all based on this model, and in the model, it has what we call tiebreaker rules. When two countries both think of a person as their resident, you get a tug of war. Mine, 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 mine. How do we decide? Well, first we look at your center of vital interests, for example. Say, Where's your bank accounts? Oh, you have them in both? Okay, well, where's your family? Oh, you have family in both. Okay, well, where is your, where do you spend more time? Oh, equal. Still having a tug of war. What is your citizenship? Every country does it, which means we're all taxing on the basis of citizenship. We're all guilty of it under treaties. We acquiesce to that. We acquiesce to that as a tiebreaker. Now, there's all kinds of ways to think about that, but I think the problem for mounting an international law challenge is if you could point to the place where we all do this and say, well, the US, you just do it too much. I think we're not going to go too far, right? So what we need is some way to articulate what the US is doing as something other than citizenship-based taxation. Because we're all doing that thing, but we don't think of it as pernicious, right? But we do think of what the US is doing as pernicious because it's intruding, right, in a really oddly everyday, customary kind of way with, grandmothers in Canada, for crying out loud. People who all of a sudden whose mobility is restricted because of fear of reprisal, of having their homes taken away. I mean, there's got to be a compelling case made. There may not be an international law case there. But I think it's worth at least understanding that you have these acquiescences that we've already made. So in a way, it's a time to re-examine those acquiescences and say, well, you know what? Maybe we need to rethink the whole charade of cooperation here. Maybe we need to see the world the way the US sees it. Information is a commodity, and the US can afford it. They can buy it themselves unilaterally without your help, Canada, without the rest of the world's help. They will just go in and take it. And if they are prepared to pay the cost to their capital markets of a 30% withholding tax, that's what they're prepared to pay. In that world, we are not working together anymore. So we get to that funny place where we start to wonder, what are we getting? What does Canada get out of an IGA? Nothing. Nothing. Canada's not going to go after Canadian citizens living in the US. It says it's a reciprocal agreement. It is not. What does the PFFI get out of its agreement with the IRS, which itself is, I'm questioning what that is exactly. The IRS just running around, entering into agreements with private industries in other countries? Interesting. In any event, what does that private bank get? Nothing in return. There's no quid pro quo here, right? It's just a pure extraction. So I think if you start to see the world in that way, you start to question, really, why are we agreeing at all to any of this? Which is why my reaction to you, Abby, was no to the IGA. No. And no PFFIs. No. And challenge any bank that blithely signs away its own rights only to turn around and force you to sign away yours or close your account, right? No to all of these and challenge all of these, right? Now, is this realistic? Absolutely not, right? Because you know what happens? All the people who will be withheld upon lose in the meantime. While we're all thinking about how to challenge, and while we're all saying no to IGA, and while I stand in an academic position and say Canada should not sign an IGA. Moreover, Canada should no longer sign any agreements with the United States ever, right? Because they do this, right? If you can stand there, and that's all very nice, and it's very clean, right? It's a nice principled position, but it's not realistic because in the meantime, the US will do what it says it will do. It will withhold. It will extract 30% gross basis on sales proceeds. And it has given itself 120 days now to consider your refund request. I'm sure it will have no problem doubling that next year when they start piling up and they don't have enough people to deal with them. So you can wait a year, 2 years, 20 years for your refund, which is effectively, and in the meantime, taxing you by having you have to hire US experts, So there's a cost, an ongoing cost to saying no that we bear now with the hopes that someday we won't have to pay that cost anymore. That is too much probably for me to ask of anyone. Nevertheless, I think that Jim Flaherty has been on record expressing not just, this seems a little odd, but expressing, I think, outrage is the right term for how he has reacted to FATCA. For Canada to turn around and sign an IGA is about as about-face as you can go. That is about as conflicted with that prior position as you can get. In other words, you could not be more submissive than that. That's all I have. Thanks.
Before any questions, and I want to get to questions, that was the most fantastic presentation I've heard on FATCA, and I was trying to think of a word, and the only thing I can come up with is simply incredible. Thank you very much. Let's open this up to questions for a few minutes and then keep this going. Over here, yeah. I think you better.
There seems to be a bit of an inconsistency between number 1 and number 2, in that the number 1 says that NAFTA overrides international law or international agreements or treaties or whatever, but NAFTA is a treaty.
No, FATCA. In other words, FATCA being later in time.
Yeah, later in time.
I'm not
FATCA
talking about
overrides treaties.
Not NAFTA, but the Double Tax Convention, the Double Tax Treaty.
But NAFTA is a treaty.
Yes, exactly. So does FATCA override NAFTA? Possible. I don't know. I'm not a NAFTA expert enough to know.
What I'm saying is that I think that if there's international override, the NAFTA isn't going to be helped. You can't argue, hey, you're breaking this paragraph in NAFTA, if they're turning around and say, well, sorry, FATCA overrides it.
Right.
You got no.
Right. So that's a very good point, and I don't know how to resolve that. Right. That I don't know how anybody brings a case of a violation of NAFTA when what we're talking about is a change in the law, right? Like, I just don't know, right? I'm not an expert on NAFTA, but what I'm telling you is the tax treaty, the double tax convention between the US and Canada has very prescribed numbers for, what they will withhold, but notwithstanding the treaty, they'll withhold 30% under FATCA. That's a treaty override, plain and simple. So could it also be a NAFTA override? Yeah, it could be. I just don't know enough about NAFTA to be. But I'm happy to tell you, say it is. Let them say it's not, right? Make the claim, call it a treaty override, and demand an accounting from the government that it's not, right?
Yeah, well, it seems like maybe it's time to turn to the canons of 1812.
Ooh, I've heard that before. Yes. No, I didn't. I did not. I don't. I know you got me on camera. I did not advocate for that. Okay. Look, let me just say this about that. I think one thing that often happens in public discourse is that we get overcome with emotion. We start running away with ideas of this is like that. No, you don't need that. You don't need this to be like anything else. You only need to focus on what this is. And I think it's self-evidently so problematic that if you keep honing in on, we have a tax treaty override, we have privacy being overridden, we have an impossible choice, a choice between two rights. Which one would we like to give up? The right to bank or the right to financial privacy? Which one do you want to give up? Because you don't get to keep one of those two. right? If you say, you don't need to resort then to, well, this is analogies of like other horrific things, right? That's, I think, a pretty bad choice, and I'm not sure why. It's only 1,350 people asking why they're being asked to make that choice, and why the government of Canada would make it for us, right? I don't know the answer. Yeah?
You realize that probably over half of those hits came from the Isaac Brock
Right,
Society.
right, right. Which I had never heard of until I started blogging this year, and now I've heard an awful lot from you folks.
Because we had that video up on our blog.
Yeah, is that, yeah, yeah. Well, movements start slow, you know?
I'm not sure who can answer this, but one of my questions I've had about implementation of these IGAs, and okay, so it relieves the banks of some of the pressure of direct reporting, and
Well, no, it doesn't. They have to still do exactly what they would have to do anyway,
Well,
just to CRA instead of IRS. It
right,
just
well,
changes,
Well, this is the
it
part I'm
just
trying to
introduces
understand.
intermediary, yeah.
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 I guess what the role is of the bank directly and then of CRA. And in the back of my mind, there have to be other government agencies involved. If part of the IGA is to then disclose this information about, national origin, citizenship, where does that information come from?
Right.
CRA doesn't have that,
No.
do they?
No, you'll be asked
So
to
this
give
is
that.
one thing I've never heard anyone talk about. Which government agencies are going to provide that information?
Well, that's the whole point. It's not an agency at all. It's the bank. I'm going to show you what they'll ask you. What is considered indicia of U.S. status? This is what your bank, this is where we were going before. The bank is the arbiter here. This is an odd place. We talked about evidence. You saw in the video that you had to give evidence. Give evidence to your bank? Well, what's the burden of proof? Who's got the burden of proof? Which is the burden of proof? How high is the burden of proof? Reasonable? Probable? Beyond any reasonable doubt? I mean, come on. What are we talking about evidence for, right? But let's just look at what the bank will ask you. Are you now or have you ever been a U.S. citizen or resident? Were you born in the United States? Do you have a U.S. mailing address or permanent address? Do you use it for anything? Anything. Like, for example, Canadians. Do you buy stuff on Amazon.com in the US and get it sent to a post office box on the other side of the border? Don't admit to it. You're a US person. Do you have an account where anywhere in the world, do you see that? An account anywhere where the only address is a P.O. box, in care of address or hold mail address? Do you have one of those? Do you have your passport in a box with a P.O. box? Do you save documents? Do you have your marriage certificate and your children's birth certificates in a safety deposit box, in a P.O. box somewhere with a P.O. box address? You're a U.S. account holder anywhere in the world, right? Now look at this one. It is hard to express how difficult this last one is. This next one is. A power of attorney or signing authority granted to a person with a U.S. address. Do you have a health care power of attorney where someone related to you is going to make decisions on your behalf and they live in the U.S.? Guess what? You're a U.S. account holder. So if your mom lives in the States, your sister, your daughter, I don't know why they were all female, but you get the idea, and you sign a power of attorney giving them power over you, this looks to me like you're a U.S. account holder. Forget citizenship, forget residence. We're talking about power of attorney. It doesn't say specific. Maybe there are specifics somewhere. I don't know. I haven't read the 400 pages of regs, right? This is advice from, well, you know who this is advice from. Big Four. They will help you through this. Right. Okay, they have the details. Right. A power of attorney or signing authority granted to a person with a U.S. address. That is, guess what? A person that themselves has any of these indicia could be that person, right? Okay. Instructions. Look at this. instructions to send payments. Are you sending money to your kid who's going to college in the US? US account. Instructions to send payments to an account in the US or any instructions received from the US. Do you have an account, a credit card in the US that has an annual fee? And do you have the fee for that paid out of your Canadian bank account? US account. Do you see how it's a Venus flytrap? It snaps very quickly. Okay, the question for compliance is who's going to ask you those questions? And I'm going to tell you that Deloitte or PwC, somebody is going to come up with a handy little form. And when you go in, once a year or whatever, they'll send you your letter to say, you know, on our annual holiday greetings. And by the way, here's all the information we have on file for you. If any of this is wrong, under penalties of perjury, you sign here. And if we don't hear from you, we'll assume it's all still true, thereby fulfilling our annual or triannual or whatever they are annual requirements to the IRS, right? And it will have on this list PwC or Deloitte or Ernst & Young, one of them will have come up with the list, and they'll write up, you know, have you ever read a credit card, the back of your credit card? Of course you haven't. It's in 2-point type, and that's what this will look like. Boilerplate, iTunes agreement style, adhesion contract style, but except it's not a contract, right? It's not a contract, there's no quid pro quo. It's not a contract. It's just you submitting to the government under penalties of perjury, probably. Right? So they'll hand you this form when you open an account, and then for all of you that have an account, they'll just send it to you in a letter, and they'll say, this is what we have on file, and FYI, we're giving it to the IRS, CRA, whoever we feel like, really. You waived your rights. And if you disagree, you know, opt out, you can send us a letter and tell us. But otherwise, we'll just assume everything's la-la, and here we go. And you won't even, this is how, you know, sort of devious this problem is that most people will not recognize what is happening. They won't even know. They won't see it until it's done. And it's possible that people will live their whole lives and not know. I don't know. But what happens is, for most people, maybe it doesn't really matter. It's not going to change their lives. It's going to be some high-profile case here, some high-profile case there, some outrage here, some outrage there. All of a sudden, you're on a no-fly list, right? So in terms of compliance, I don't know how to say this, but bankers are not lawyers. And when you get that little form that you don't read and you don't opt out, or they have you click it when you go to, worse, they have you click it as new terms of service when you go to use your online bank account. Can you just see it? They put it in there, 900 pages. You can just scroll to the bottom, click, I agree. Did you read all that? Nobody in there. You agreed you were a US account holder, or if we thought you might be, you had one of these indicia, then blah, 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 blah. And you just click through to get to your checking account, right? So I think we're going to see some pretty creative, hey, this is the age where we just give all of our information to everybody. What's new about this? We'll give it to Facebook. Why not to the IRS? Right? And we can't, it's too much to bear, right? Yeah.
About the, like, let's say there's a person that has a U.S. place of birth. They don't meet any of the other criteria,
Yeah, all you need is one.
right?
Any one.
Well, at the bottom it says having one of these indicia does not mean whatever, but
Yeah, but
that would
think
be
about that from the banker's point of view. Are you going to tangle with the IRS? Oh,
right.
they had
So
one, but
basically we have bankers making legal
Yeah.
decisions.
Yeah.
Okay. And so somebody
well,
who
compliance officers. I mean, there's going to be an industry for that.
will be an in-house lawyer maybe at a
Absolutely.
Okay.
Yeah.
But these people that, let's say, and there's a lot of them that, let's say, you know, became citizens before 86 or before 94, who obviously have a U.S. place of birth,
Right.
do not consider themselves U.S. citizens. But it's a
Ignorance
group-
of the
but
law
it's
is
a
no
gray area,
excuse.
and they cannot produce a certificate of loss of
Right.
nationality, which is what the banks probably would want to see.
Who knows what they'll need to see,
then,
right? Yeah.
then they're going to be
Yeah.
either recalcitrant or they're going to have their account closed.
Yeah.
Right.
They probably won't be
So there is
recalcitrant.
there will be no gray areas.
No, exactly.
Okay. Okay.
I mean, that's right.
And there is no thing that says, well, I feel I'm not a
No.
U.S. citizen. They will make that determination.
You know, we like in the tax law to call these objective factors. These are objective factors. You can't just go around self-selecting in or out of these things with how you feel. We don't care how you feel. We have objective factors. So it's the rule of law. We got to treat everybody the same. Yeah.
I have a question about the Intergovernmental Agreement. So are they, am I right in saying they're starting to introduce self-declaration stuff as well? So I think when I read the model agreements from the IRS that there is some self-declaration. So they will be mandating that people, if they follow these model agreements, self-declare whether or not they are a U.S. person. And then if the banks already have indicia on their file, so it's, the way it's currently structured in these model agreements is not necessarily that if they don't have on file that you're a U.S. citizen, you're born in the U.S., you're not necessarily mandated to inquire in detail whether you have any of this indicia, but they will be demanding that you self-certify whether or not you're a U.S. person. And if that conflicts with any of the information that they do have through their normal course of business, then you will be caught up into this.
Right.
And then, of course, if you have not accurately self-declared, that's a really big deal, and the self-declaring in itself is very coercive. But so this is part of it, right? It's in flux, it's a moving target, and
Absolutely,
it's still
yeah.
not clear what this will look like. When you go to the bank, will you be required to, in detail, fill out these indicia, or will you be required to sign something and then you don't know what they have on you, or anyway, so.
I think all of the above, right? We'll
Yeah.
just, it'll be every available, yeah.
I'm sorry, I have to leave.
Oh, I'm sorry. Bye. Thank you.
Probably a good moment for, I mean, this is fascinating, but probably a good moment for a 5-minute break. I'm sure you're happy to continue to
Yeah,
take
of course,
questions
yep,
during the
of
break.
course,
And
yep.
then we'll pick up with guest speaker from Washington. 5 minutes.